Welcome to this explainer. If you're navigating the intellectual property landscape right now, there is basically one huge question that dominates almost every initial conversation we have, and that is, what is this actually going to cost? Well, today we are going to completely demystify the true cost of a non-provisional utility patent application in 2026. And we're not doing this as just outside commentators. We're coming at this from our perspective as former USPTO examiners. We know exactly how these numbers break down because, frankly, we've spent over 25 years sitting on both sides of the examiner's desk.
So, let's just cut to the chase and start with the big picture number. A non-provisional patent application is going to cost you somewhere between $3,000 and $17,000, or honestly, sometimes even more in total. Now, yeah, that is a massive range. But as we'll see, it's actually entirely predictable once you understand the variables at play here. Specifically, who is filing it, your entity status, and the actual technical complexity of your invention.
Here is our roadmap for today. We'll quickly cover the true cost breakdown, USPTO filing fees explained, attorney fees by complexity, anticipating prosecution costs, strategic cost reduction, and finally, getting your specific estimate.
All right, kicking things off with Part 1, the true cost breakdown, where we separate rigid government fees from variable legal costs.
The very first thing you need to grasp is that the total cost is not just one big, mysterious lump sum. It's actually split into two distinct layers. And recognizing how these two layers interact is exactly what separates a realistic, well-planned budget from a really unpleasant surprise down the road. On one side, you have the USPTO government fees. These are essentially the rules of the game. They're fixed by statute and determined entirely by your entity classification. You literally cannot negotiate these. On the flip side, you have the attorney fees. This is your variable layer. These fluctuate based on the technical depth and the specific requirements of your actual application.
Moving right into Part 2, USPTO filing fees explained. Let's look at your baseline government investment.
Every single non-provisional application requires baseline fees paid right at filing. We're talking a basic filing fee, a search fee, and an examination fee. Think of this as the absolute floor of your total cost before a single hour of legal work is even billed. And your entity status matters immensely right here. I'm going to read the total fees, which includes the issue fee upon allowance, and I want you to mentally map where you or your company falls. For a large entity, the total USPTO fee is $3,290. For a small entity, which is like a company with 500 or fewer employees, that total drops to $1,316. And for a micro entity, typically individual inventors below a certain income threshold, that total is just $658.
But you've got to beware of the surcharges that can totally catch applicants off guard. For example, if you don't submit your specification, claims, and abstract in DOCX format via the USPTO's Patent Center, you are going to get hit with a non-DOCX surcharge ranging from $86 to $430. Also, if your application includes more than 3 independent claims or more than 20 total claims, you will pay excess claim fees. With complex filing strategies, this can quickly add several $100s right to your baseline government cost.
On to Part 3, attorney fees by complexity. This explains why your invention's technical depth absolutely drives the cost.
Attorney fees are the largest variable cost, and they're driven almost entirely by technical complexity. Unlike government fees, these aren't based on your company size. Complexity dictates the specification length, the claim count, and the intricate drawing requirements. Let's look at the spectrum here. A simple mechanical device with a low claim count and straightforward drawings might cost somewhere between $2,000 and $5,000 to draft. In fact, at our firm, our base drafting fees generally sit right in that $2,000 to $5,000 range. But on the other extreme, biochemical or pharma inventions involving sequence data or biological deposits, those can easily range from $10,000 to $15,000 or more. That isn't just some flexible quote. It reflects the real tangible differences in the heavy preparation work required.
Here is the insider reality of exactly why complexity costs money. Under 35 U.S.C. Section 112, every single claim in a non-provisional application must find explicit written description support in the specification. As former examiners, we can tell you, examiners will apply rejections the absolute second a claim recites an element or relationship that isn't meticulously described in your document. The more complex your invention, the more edge cases, technical relationships, and embodiments require documented support. That just takes significant attorney time to get exactly right before filing.
So here is the absolute crucial point, and this is something most cost guides completely bury. The relationship between upfront preparation quality and downstream prosecution length is direct.
From our experience inside the USPTO, we have seen firsthand that the applications generating the most expensive problems later are almost never the ones that cost the most to prepare up front. Actually, they're the ones drafted cheaply, without sufficient specificity. Applications that arrive with thin specifications and overclaimed scope, they trigger multiple rounds of office actions. Listen, examiner-level drafting is not a premium luxury. It is fundamentally a prosecution cost reduction strategy.
Let's look at Part 4, Anticipating Prosecution Costs and the Predictable Stages You'll Face After Filing.
Filing your application is really just the beginning of an 18 to 36-month journey. A good attorney prepares you for these costs up front, rather than letting you discover them months later. These are predictable post-filing budget items that regularly catch inventors unprepared, but they really shouldn't be gotchas. First, a prior art search, which runs about $1,000 to $3,000. Then, office action responses. After that, post-grant maintenance fees to actually keep your patent alive. And finally, optional programs like Track 1 Prioritize Examination, which can reduce your time to a first office action to under 12 months for an extra fee. Again, these are standard parts of the process.
For office action responses specifically, you need to budget between $2,000 and $4,000 per round. The vast majority of applications require interaction with an examiner before reaching any kind of decision. When you get rejections for novelty or obviousness, your attorney has to provide detailed arguments and often make claim amendments. You absolutely must plan for at least one round of these costs when calculating your overall total investment.
And even after you secure the allowance, there are maintenance fees. To keep your utility patent in force, fees are due at very specific intervals: 3.5 years, 7.5 years, and 11.5 years from the grant date. If you fail to pay these, your patent simply lapses into the public domain, which means your competitors can freely practice your invention. Definitely not what you want.
Which brings us right back to that core tension we talked about. A prior art search before drafting allows us to scope your claims around the existing landscape rather than just filing broad claims blindly. Skipping this search might save you a little bit of money at filing, but it virtually guarantees multiple, highly expensive office action rejections later. A $1,500 search on the front end can easily prevent $6,000 to $12,000 in prosecution responses on the back end.
Moving right along to Part 5, Strategic Cost Reduction. Let's cover how to lower your budget without weakening your protection.
So, how do we practically lower your budget without sacrificing your IP? Well, here are the actionable insider tactics we recommend. First, confirm your micro or small entity status immediately. It's literally the fastest cost reduction available and saves hundreds in USPTO fees. Second, submit exclusively in DOCF's format to just eliminate that totally pointless surcharge. Third, conduct that prior art search first. And fourth, invest in drafting with examiner-level specificity. Let me say it again. Doing it right at the start is the absolute ultimate way to prevent costly, drawn-out prosecution rounds.
But I have to give you a critical warning here. Do not just blindly cut claims to save on filing fees. Yes, trimming independent claims can save you a few $100s up front, but your independent claims define the very outer boundaries of your legal protection. Trimming them without strategic analysis is a massive protection problem disguised as a budget decision. That trade-off requires deep attorney judgment, not just a simple calculator.
Finally, Part 6, Getting Your Specific Estimate. Moving from broad ranges to actual numbers. We've given you the realistic frameworks and the broad ranges today, but to move from a broad range to an actual number, a true estimate, absolutely requires reviewing your specific invention. Every single invention has unique complexities, unique prior art landscapes, and unique business goals. A realistic budget simply cannot be determined by looking at a generic fee schedule on a website.
And really, that is where the differentiator lies. Having former examiners review your invention means you aren't just getting a guess, you're getting a real, actionable number you can trust, backed by over 25 years of insider USPTO knowledge. We look at the exact technical depth your idea requires, and we map out the most cost-effective path from filing all the way through to issuance.
So we leave you with this final thought. What is the actual cost to protect your unique invention? Stop guessing with broad ranges. If you want a specific estimate tied to your actual situation, it's time to reach out so we can review it together. Thanks so much for joining us for this explainer, and we really look forward to helping you navigate your patent journey efficiently and effectively.